Hey, real estate students, Alexei from LexaWise here. One of the most important and most tested topics on the real estate exam. Whether it's the national or state portion, you can expect several questions that will challenge your understanding of contract law and how it applies in real estate. That's why I've prepared 25 real estate practice questions on contracts to help you master this key area. We'll work through each question together, give you a chance to think, and then break down the correct answer with a clear explanation.
LexaWise, Real Estate Exam Prep.
Let's move on to the first question. If upon receipt of a purchase under specific terms the seller makes a counteroffer, the prospective purchaser is A. Bound by the decision of the agent, B. Relieved of his original offer, C. Forced to accept the counteroffer, D. Bound by his original offer. Think about it. The correct answer is B. Relieved of his original offer. A counteroffer serves as a rejection of the original offer and is considered a new offer with modified terms. That means that the original offer is no longer valid and cannot be accepted later. Next up, what is the term used to describe a written document that transfers ownership of tangible property? A. Mortgage. B. Blanket mortgage. C. Listing. D. Bill of sale. Take a second. The correct answer is D. Bill of sale. A bill of sale transfers ownership of tangible property, such as furniture or vehicles. On the other hand, a real estate contract is a legal agreement between a buyer and seller for the transfer of real estate property, which includes land and anything permanently attached to it, such as buildings, homes, and other structures. And here's your next one. Sellers negotiate a listing with a broker, stating that if they find their own buyer, they can save the commission. However, if the broker, their agent, or any other brokerage firm finds the buyer, then the sellers will have to pay the broker's commission. What type of listing did the sellers and broker just negotiate? A. Net listing. B. Exclusive agency agreement. C. Exclusive right to sell. D. Open listing. Got your answer? Well, B is the correct answer, exclusive agency agreement. The exclusive agency agreement entitles the broker to a commission if anyone other than the seller finds a buyer. Let's continue with this question. What is meant by specific performance? A. A contract that has been fully performed. B. A contract where either party has the right to cancel the contract provided legal notice is given. C. When all parties of the contract have agreed. D. A legal procedure or action brought by either the buyer or the seller to enforce the terms of the contract. Take a moment. The correct answer is D. A legal procedure or action brought by either the buyer or the seller to enforce the terms of the contract. In legal terms, specific performance is a remedy that obligates one party to fulfill their contractual obligations exactly as they were agreed upon. Next question. This one presents a scenario. Let's read carefully. Old man Douglas wishes to sell his land and distribute the proceeds to his children. Broker Dane lists the property, and an offer is made by crazy old widow Sully 6 months later. Douglas accepts the offer without any modifications, and broker Dane delivers the contract to the widow. What factors could prevent this contract from being binding? A. Either widow Sully is incompetent, or widow Sully's death before Dane can relate Douglas's acceptance. B. Widow Sully is in fact incompetent. C. Widow Sully's death before broker Dane can relate Douglas's acceptance. D. Nothing. What do you think? If you said A, you are correct. Either widow Sully is incompetent, or widow Sully's death before Dane can relate Douglas's acceptance. The contract can't be formed or executed if one of the parties involved dies or becomes incapacitated before the agreement is finalized. Let's keep it going. Out of the following, the one that is not an essential element of a real estate contract is A. Valuable consideration. B. Competent parties. C. Offer and acceptance. D. Good consideration. Think it through. The correct answer is D. Good consideration. For a contract to be legally binding, It must have valuable consideration, which can include money, real estate, or other tangible assets. While love and affection can be considered as good consideration, it is not usually recognized as valuable consideration because their value cannot be readily determined. Let's move on to the next one. What is the name of the law that mandates specific real estate contracts to be in writing for them to be considered enforceable? A. The Statute of Frauds. B. Parole Evidence Rule. C. Written Instrument Law. D. Statute of Limitations. Pause and decide. The correct answer is A. The Statute of Frauds. The Statute of Frauds relates to contracts involving the purchase, sale, or exchange of real estate. But keep in mind that this does not apply to listing agreements. All right, next question coming up. In a situation where the heirs of an estate are selling their deceased father's house and have removed a bedroom set, a matching organ bench for a built-in organ, a television, and several renowned paintings, which item among these would be classified as real property? A. Organ bench. B. Bedroom set. C. Famous paintings. D. Television set. Take a moment. The correct answer is A. Organ bench. The organ bench is regarded as real property since it was specifically designed to complement a built-in organ. In contrast, the television and the remaining items are considered personal property. All right, let's continue with the next one. Which one provides the most accurate description of an option among the given choices? A. An agreement with consideration granting exclusive rights to buy or lease a property at a given price within a stated period of time. B. A clause that allows either party to terminate the agreement as long as proper legal notification is provided. C. A legal process or action initiated by either the purchaser or the vendor to uphold the conditions stipulated in the agreement. D. A document that plays a role in finalizing real estate transactions. Pause and take a moment. The correct answer is A. An agreement with consideration granting exclusive rights to buy or lease a property at a given price within a stated period of time. An option is a unilateral contract that grants a party the exclusive privilege to purchase or rent a property at a specified price during a defined time frame. That is distinct from a real estate sales contract, as the latter is enforceable by both parties bilaterally, whereas an option can only be enforced by one party unilaterally. Let's keep going with the next one. When a potential buyer is not prepared to buy a property immediately and instead decides to rent it with the option to acquire it after 2 years, what type of agreement does this purchase option exemplify? A. Bilateral contract. B. Promise and exchange contract. C. Unilateral contract. D. Mutual contract. Think about it. The correct answer is C. Unilateral contract. Options represent unilateral contracts. In such agreements, the seller is required to sell the property, but the buyer does not have an obligation to complete the purchase. Next question. Michael decides to sell his cabin on the lake and offers it in a letter to his regular postman, Gavin, at a price of $4,000. The next day, Michael receives a note from a neighbor, a close friend of the postman, who says, "I accept your offer." Is Michael obligated to sell to the neighbor? A. Yes, because the acceptance was within 2 days. B. No, because only the offeree can accept an offer. C. Yes, because both the offer and the acceptance were in writing. D. No, because there was no involvement from a licensed agent. Got your answer? The correct answer is B. No, because only the offeree can accept an offer. Only the offeree can accept an offer, and the neighbor's acceptance is invalid regardless of when or how it was communicated. The neighbor's response actually constitutes a new offer that Michael may accept or decline at his discretion. Let's move on to another one. Bruce and Monica have entered into an agreement in which Bruce will purchase Monica's house at the listed price on the condition that Monica will install a new roof and Bruce will be able to obtain a loan that is enough to cover the purchase. Until both of these conditions are met, the contract is considered A. rescinded, B, executed, C, executory, D, voidable. Take a second. The correct answer is C, executory. An executory contract is a type of contract in which the involved parties have agreed to the terms, but some conditions still need to be met by the parties. Once all the conditions are satisfied and only the closing remains, the contract is considered complete or executed. All right, the next question. A developer of a subdivision hires agent Lori to sell their lots. While selling lots, Jason, a licensed agent, makes an offer to purchase lot B3 for $20,000, and a sales contract is created. However, due to a typographical error that went unnoticed, the contract identifies the lot as D-3, which has a listed price of $25,000. What is the current status of the contract? A. Void. B. Enforceable. C. Voidable. D. Invalid. Pause and think. The correct answer is C. Voidable. Even if an agent is involved, the client remains responsible for reviewing and understanding the documents. In cases where there is a mutual, unintentional material mistake, and without negligence, the contract may become voidable, allowing the developer to either rescind the contract or choose to honor it. Next, Mr. Adams made a written offer to purchase a home through Broker Smith, but passed away before being notified of a qualified signed acceptance by the seller. Which of the following statements is correct? A. The offer is still valid and Mr. Adams' estate is responsible for completing the transaction. B. The offer made by Mr. Adams was terminated due to his death. C. The offer is no longer valid and the seller is responsible for returning any earnest money Mr. Adams paid. D. The offer is still valid and the seller is legally required to honor it. Think for a moment. The correct answer is B. The offer made by Mr. Adams was terminated due to his death. In the scenario described, Mr. Adams passed away before being notified of a qualified, signed acceptance by the seller. Since the seller never accepted the offer, it is not a legally binding contract, and Mr. Adams's death has rendered the offer invalid. The seller is therefore free to consider other offers and is not required to honor the offer made by Mr. Adams. Next question. A tenant agrees to make certain repairs on the property he is renting from the owner, but fails to do so despite several assurances. Later, the owner creates a contract and forces the tenant to sign it by threatening eviction if he doesn't comply. That contract would be A. Illegal, B. Enforceable, C. Voidable, D. Null. Think for a moment. The correct answer is C. Voidable. Contracts entered into under duress or with the threat of force or intimidation are considered voidable. If someone is forced to sign a contract against their will, it becomes voidable, so the parties can choose to reject it. Let's keep going. If a broker enters into a verbal agreement with a seller without obtaining written confirmation subsequently, what is the status of the commission payment owed to that broker? A. It is prohibited according to the Commissioner's regulations and rules. B. It is illegal. C. It is contrary to public policy. D. It is permissible if the seller elects to do so. Take a moment to think. The correct answer is D. It is permissible if the seller elects to do so. If a broker takes an oral listing without obtaining subsequent written verification, a commission payment is only permissible if the seller agrees to pay such a commission. However, if the commission payment is not confirmed in writing, it is unenforceable in a court of law due to the statute of frauds. Let's go to the next one. Under what circumstances can a real estate broker acting as the seller's agent decline to present an offer to the principal? A. Never. B. When a backup offer has been accepted by the owner. C. When the broker is acting on the express instructions of the principal in his refusal. D. When the broker is acting as a free agent. What do you think? If you said C, then you are correct. When the broker is acting on the express instructions of the principal in his refusal. An agent's role is to execute the orders of their principal. Although they can provide recommendations to the principal, their ultimate responsibility is to follow the principal's directions, provided that they are legal. All right, one more. Which of the following has to be in writing according to the Statute of Frauds? A. A rental agreement for a tree that bears fruit or nuts during its harvest season, allowing for the gathering of its produce. B. A single-family residence offered for sale by owner. C. A 5-year lease for a commercial retail outlet. D. A seaside rental from February 10th to May 10th. Think it through. The correct answer is C. A 5-year lease for a commercial retail outlet. The Statute of Frauds defines which agreements must be documented in writing to be enforceable. Any agreement that extends beyond 1 year, as well as any contract involving real estate that leads to compensation, such as a listing contract, must be recorded in writing. Let's dive into the next question. What is the name of the lease agreement in which a commercial tenant agrees to pay a base monthly rent of $2,500 in addition to 2% of their monthly gross sales? A. Ground. B. Net. C. Percentage. D. Option. Take your time. The correct answer is C. Percentage. In a percentage lease, a portion or the entirety of the rental amount is determined as a fixed percentage of the tenant's total sales revenue generated on the leased property. Let's keep going. What option is available to a principal if they no longer wish to have a broker represent them during the term of an exclusive right-to-sell listing agreement? A. The principal can cancel or withdraw the agency established by the listing contract without being held liable for damages. B. The principal cannot revoke the agency because an exclusive right-to-sell listing agreement is a contract that is legally binding and cannot be cancelled. C. The principal may revoke the agency created by the listing contract but may be liable for damages. D. The principal may be obligated to sell his property. Pause a moment, no pressure. The correct answer is C. The principal may revoke the agency created by the listing contract, but may be liable for damages. If the principal decides to terminate the agreement and withdraw the broker's agency during the listing period, they may do so, but they may be responsible for any damages or losses that the broker incurs as a result of this action. The terms of the contract typically outline the circumstances under which the principal may terminate the agreement and any compensation or damages owed to the broker in such cases. Next question coming up. When a seller enters into an open listing agreement with 5 different brokers for the sale of their home, A. Each broker has an opportunity to earn the entire commission. B. The brokers are going to split the commission 5 ways, no matter who sells it. C. The owner must pay the first broker to take the listing, regardless of who sells it. D. The owner must pay a full commission to every broker when it sells. Think carefully. The correct answer is A. Each broker has an opportunity to earn the entire commission. An open listing agreement allows multiple brokers to work concurrently to sell a property on behalf of the owner. The broker who first finds a buyer who is prepared, eager, and capable of purchasing the property under the conditions outlined in the listing agreement earns the commission. All right, here's the next one. What is the responsibility of broker Morty, who has obtained an exclusive listing agreement for a property owned by 3 individuals and has visited each of their workplaces to obtain their signatures on the contract? A. Provide 1 copy to any of the 3 owners. B. Join them together in one place to sign simultaneously. C. Provide a copy to each owner when he or she signs. D. Provide a copy to the first owner who signs only. Think it over. The correct answer is C. Provide a copy to each owner when he or she signs. In situations where a property has multiple owners, the broker is obligated to provide a copy of the listing agreement to each owner when they sign it. Let's move on to the next question. Penny, a salesperson, has multiple listings and works as an agent for broker Amy. That makes those listings: A. the property of salesperson Penny and broker Amy. B, the property of salesperson Penny. C, void if salesperson Penny changes brokers. D, the property of broker Amy. Think about it. The correct answer is D, the property of broker Amy. A listing agreement is a legally binding contract between a seller and a broker. If a salesperson, such as Penny, decides to switch brokers, the original listing agreement remains the property of the original broker, Amy, if the agreement remains valid. Let's dive into a new question. After the termination of a listing contract, the broker receives an offer in the mail. The offer is for full price and includes all of the seller's terms and conditions. Why is this not a valid contract? A, there is no lawful objective. B, they did not discuss the amount of earnest money that should be involved. C, no acceptance has been given. D, there is no valuable consideration. Think you got it? The correct answer is C. No acceptance has been given. The offer received by the broker in the mail, even though it includes all of the seller's terms and conditions and is for the full price, cannot be considered a valid contract because it has yet to be presented to or accepted by the owner. However, even though the listing agreement has expired, the broker should present the offer to the owner. If the owner accepts the offer and the transaction closes, the broker is generally entitled to their full commission. Let's move on to the final question. When leasing commercial property that is merely a shell space, the landlord often agrees to spend a specific amount to help a qualified tenant build the space out. This amount is designated as A, a rent abatement, B, earnest money deposit, C, a security deposit, D, a tenant improvement allowance. Got your answer? Well, the correct answer is D, a tenant improvement allowance. A tenant improvement allowance refers to the resources provided by a landlord to a tenant for the purpose of creating a space suitable for occupancy. This allowance covers both the improvements to be made above the ceiling, such as HVAC systems and electrical lines, as well as those below the ceiling, such as doors, walls, and flooring. This allowance may also be referred to as a TI allowance, TIs, or a construction allowance. And that's it. Great job making it through all 25 contract questions. The more you practice, the more confident you'll be on exam day. For more practice, study guides, and tips, visit lexawise.com, link in the description. Don't forget to subscribe, hit the bell icon, and keep preparing. You're ready to pass your real estate exam.